presentation, we will talk about legal writing. Let's go! So, before we proceed, what is legal writing? Legal writing is the kind of writing used by lawyers, law professors, judges, and other workers in the field of law to express legal rights, obligations, and opinions. There are three types of legal writing. First type is informative writing. Conveys information on issue involving the law or a person's legal rights. This type of legal writing does not take sides. Its goal is objective communication by predicting the law's path vis-a-vis a set of facts regardless of who is involved. Example of these memoranda, letters to clients, and statement of facts in brief. So the next type is persuasive writing. It convinces the reader to accept a certain viewpoint. Here, the writer argues for a particular side or perspective. He is expected to use available legal tools to support his thesis. These may be pieces of evidence offered in court, sections of the law, decisions of the Supreme Court, opinions of the legal authorities on a subject. Example of these: academic legal writing, motions, pleadings, and argument sections of the brief. Lastly, functional writing is designed for specific use or result in law. These are deeds, wills, contracts, or draft of laws, and ordinance which legally bind those involved. Some specific format, ceremony, or legal requirement may be present in this type of writing. This type of writing need not to be analytical nor persuasive. It is enough to be accurate and complete, yet understandable. These are the elements of legal writing. The first element is simplicity. In writing means to write plainly and simply, to observe the rules on economy of expression. Each sentence must say what the writer means and means what the writer wants to say. Convoluted words and word constructions must be avoided. This is best done by preferring shorter sentences and choosing shorter words. Repetition must also be avoided as much as possible. How to write simple. Avoid wordy expressions. Example, wordy: the cars were bought for the purpose of starting a taxi business. Concise: the cars were bought to start a taxi business. Avoid elaborating on the abuse. Example, wordy: a baby girl was born to spouses Reyes. Concise: a girl was born to spouses Reyes. Third, get to the point. Example, we are very proud and happy to announce that our office won the golf championship this year. Concise: our office won this year's golf championship. Fourth, avoid tautology. Please voice out your opinion. To concise, please voice your opinion. Fifth, eliminate certain phrases. This is a topic that interests me. To concise, this topic interests me. Lastly, minimize the use of connectives and relative pronouns. Clarity. In writing result, when the writer is able to express exactly and unambiguously what he wants to be reflected on his work, the last thing a writer would want is to confuse his readers. On one level, clear writing involves clarity of expression and sentence structure. On another, deeper level clarity refers to clearness of one's logic and argument. Rules in clear writing. Be clear on your point. Make sure your point is communicated at once. Have a structure. This is where you put your data, analysis, and argument. Observe grammatical rules. Be precise. Be consistent. Be logical and clear in your argument. The last element is persuasion. It's a process where people are guided towards the adoption of an idea or course of action. In legal writing, a persuasive document attempts to influence the deciding authority to favorably decide the case in favor of one client. The deciding authority is usually the judge. However, he may also be the arbiter in an arbitration dispute, commissioner, hearing officer, mediator, or the other party to the dispute. So, modes of reasoning. So, what is reasoning? Reasoning is the process of drawing conclusions from facts or evidence to reach the desired conclusion. Arguments and proof may be used. So, there are 4 modes of legal reasoning. First is rule-based reasoning. Second is analogical, the counter-analogical reasoning. Third is the policy-based reasoning. And the last is the narrative reasoning.